Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome back to Ask a Lawyer here on CP24. Good to have you along for the half hour. If you could stick around for the entire thing, you're going to learn a lot for sure. John Scholes here, and joining me momentarily, employment lawyer Lior Samfiru. Anytime you want to reach out to Lior, we always give the contact information off the top because we always get emails afterwards saying, how do I reach you guys? 1-855-821-5900. Ask at EmploymentLawyer.ca, and the website, which I know Lior is going to refer to a few times, at least over the half hour, that is pocketemploymentlawyer.ca. There you will have access among the nice bits of education on the website. It's built just for you. You'll also have access to the Severance calculator. It does exactly what it was meant to do, and millions of Canadians have taken that out for a spin. Again, pocketemploymentlawyer.ca. Main topic in just a bit. If you're an employee, do not do these things. We'll got a list. We'll get through that a little later in the show. Some phone calls from one of our radio shows, which, by the way, you can catch here locally in the GTA. Sundays, 1 p.m., News Talk 1010. Please join us. Call the show. Maybe you'll get on this show eventually, too. So we'll get to all that and lots more here on Ask a Lawyer over the next 30 minutes. But we always get things warmed up. We get kicked off with the week that was, our case of the day. Lior, what do you got going on, pal?
Hey, John, great to be here. Great to be talking employment law. There's so much to cover on this show every single week because the questions don't stop. Maybe you're now doing well and things are going just fine, but sometimes things will happen that change the dynamic. All of a sudden, your boss does something or says something, or maybe you got a new boss and you're not really getting along. Well, you may have certain rights that you didn't appreciate. So on this show, we cover this very important topic, employment law. We all have jobs. And what flows from that is we all have rights. We have significant employment law rights that we all have. They're there whether we know it or not. Well, by watching this show, you'll know what your rights are. If you lost your job, if you're mistreated, if you've been constructively dismissed, bullied, harassed, discriminated against, you name it, on this show, you'll learn everything you need to know about those rights. And of course, if we don't cover your specific topic here on the show, if you want to continue that conversation with me, easy to do that. Phone number and email address throughout the show, you'll get that. Don't hesitate to reach out. So let me tell you about a situation that came across my desk. Now, John, I've spoken many times here about severance deadlines, and I've spoken about how the fact that that deadline, when you lose your job and there's a deadline, it's meaningless, it doesn't do anything, and it's a pressure tactic. Well, I spoke with a gentleman that lost his job after 12 years of employment. And the company that he was working for offered him, guess what, 12 weeks of severance. But they said, we need you to sign this by tomorrow. This is a good offer, they said. We really only owe you 8 weeks. We've offered you 12, so we need you to sign this by tomorrow. Man, what a short deadline. He calls me very nervous, very upset, says, I need to speak to you immediately. That deadline is about to expire. I speak to him, and of course, John, he's owed not 8 weeks, not 12 weeks. He's owed about 12 months of severance. That company, to me, clearly knew that they owed more, and they were trying to get away with it by imposing this very strict deadline. They were hoping that by imposing that deadline, he won't have time to get advice, and he'll accept that inadequate severance package. Imagine accepting 12 weeks of severance when you are legally owed 12 months. So this is a reminder. That severance deadline is meaningless. Your legal rights don't expire at Friday or Thursday or whatever that deadline is. Your legal rights don't expire for 2 whole years. Once you sign that severance offer, you're stuck. You're done. Can't help you. You're not going to get what you're owed 90% of the time. That severance that you were offered is a lot less than what you're legally owed, what the law says you should have. Do the smart thing, do the right thing, call me despite that deadline.
It's a great pressure tactic. Works really well. So if you were to, in your office, have 10 severance offers in front of you, they all have a deadline of tomorrow next week, how many out of those 10 people would say, I got to panic and do it without calling you? Well, hopefully they've learned now, but...
You know, usually I would say 7 or 8 out of 10 are going to sign this because they feel that pressure and they don't know any better. But hey, if you're watching the show now, you know better. So you won't let that happen to you, your friends, your family. tell them to make the call instead.
As I did mention, talk about making a call. You can make a call through our radio show Sundays, 1 p.m. News Talk 1010. Get on air with us, ask your questions, and we take the good phone calls. Well, we take a lot of great phone calls, but we play some back here and we talk about them, as you know, Lior, every week. Our first phone call is coming up right now.
A few weeks ago, I was called into work, and I was middle management, and they demoted me, and I lost over $14,000, and they said at the time the only job available was like a clerical position. So now I'm reporting to someone who used to report to me. I asked if I was being terminated. They said no, because they felt that there was a job there for me. It would have been better had they terminated me to give me a package. Do I have any legal recourse?
How long have you been with this employer?
25 years.
Wow. How long ago did this change happen?
About 3 weeks ago.
Still under the wire. Still good, right?
Well, absolutely.
Yeah.
But let's be very clear here. This is a classic constructive dismissal. If I was going to make up a scenario that's a perfect constructive dismissal, it wouldn't be any more perfect than this scenario. An employer does not have the right to do that. They can't just demote you, take away your compensation, your job, your responsibilities, and to say, well, we can do that because there's a job available to you. Well, what if you're the vice president and they demote you to being parking cars part-time? Well, clearly they can't do that. So that demotion that she got allows her to consider this to be a termination. She doesn't have to wait for them to give her a severance package. She can make them pay her severance package because of the fact that this is a constructive dismissal. Same with you at home. If your job is changed, your pay, your hours, your responsibilities, or it's a demotion, that's a constructive dismissal. You are owed severance. So in this situation, the question, of course, becomes how much severance? We've mentioned it before, but we're going to take it out for a spin right now. We're going to use our severance calculator tool. You can find that, of course, at PocketEmploymentLawyer.ca. And let's see how much severance this lady is owed after being constructively dismissed. So she's in a middle manager position. She was there for 25 years. Company says no severance for you because we have another job for you. Nonsense. You see right there, she's owed right around 24 months pay, 24 months of severance. This is without actually being let go because it's a constructive dismissal. Same with you at home. If that happens to you, you know what to do. Go to PocketEmploymentLawyer.ca.
That would be an early Christmas gift for that particular caller, Lior. There you go. We're going to take a short break. As mentioned off the top, if you're an employee, do not do these things. We're going to work our way through that list. So stick around for it as we're just getting warmed up, and lots more Ask a Lawyer here on CP24 is coming right up.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. John Scholes and, of course, employment lawyer Lior Samfiru is here every week answering your questions. Reach out to Lior anytime. Phone number always 1-855-821-5900. Ask@EmploymentLawyer.ca. You can also use the QR code on the screen there as well anytime. Okay, main topic, Lior. If you're an employee, don't do these things. It's a good list. It's we could have done 100 of these things, but we don't have time. First one, sign an employment contract without having it reviewed. Death sentence.
Yeah.
Not good.
Things you don't want to do, and that's a very important one. So first of all, when it comes to employment agreements, remember the rule that less is more. In fact, you would rather not have a written employment agreement. You'd rather meet your new boss for coffee, shake his hand, and say you're starting Monday. That's fine. But if you're looking at an employment agreement, don't just look at your salary and your vacation pay and whether you get a bonus or not. There are other terms that are potentially more important. An employment agreement can significantly limit entitlements that you would otherwise have. Take those entitlements away. It could limit your severance. It could be the difference between getting 24 months severance and getting 8 weeks of severance. Massive, tens of thousands of dollars. It could give a company the right to change your job, to change your pay, things that they can't otherwise do, but they can if you sign an employment agreement that gives them that power. It could allow the company to put you on a temporary layoff, to relocate you. So very important. Don't just sign that employment agreement without understanding what you're signing. The good news is those things can be negotiated. So I'm not just saying that to you to scare you away from signing. I'm telling you, you can actually negotiate those terms. You go to your employer and you say, employer, here's some concerns I want to raise. Absolutely, things can be negotiated. So do the smart thing. If you're asked to sign a new employment agreement, whether you just got a job or maybe you're an existing employee and your company wants you to sign an agreement, don't sign it without me seeing it first.
All right, number two, the thing you do not want to do, Lior, accept significant changes to your job, just like our first phone call in the first segment, right?
So we've established already, John, that an employer does not have a right to make significant changes to the terms of your employment. They don't. But the law also says if you want to accept changes like that, you can. Obviously, the law is not going to stop you from accepting those changes. So maybe it's a pay cut, or maybe it's a demotion. The problem with you accepting those changes is now the company has the right to do it again and again. And you may have thought, well, I'll take this pay cut because I want to be the good soldier, and it's just going to be a one-time thing. It's never going to happen again. Well, guess what? Because you accepted that one pay cut, now the company can do it again and again, and you won't be able to stop it. You won't be able to do anything because you set that precedent. So very important. Don't do that. When you're facing significant changes, think, am I comfortable with this happening again? If not, it may be time to say constructive dismissal. I'm going to leave. I'm going to treat this as a termination and get my severance. Of course, no one quits. I don't want anyone to quit without speaking to me first.
We are talking things you should never do as an employee. Number three on the list is this, Lior, accept a verbal termination.
So here's the problem with the verbal termination. An employer terminates you verbally, and you say, okay, now I want my severance, and they come back and say, well, no, you quit. And if there's nothing in writing, it's going to be tough to say, did you quit? Were you let go? Was there something else going on? I've seen this happen many times when a company realizes, holy cow, we owe this guy 18 months of severance. Let's just say that he quit because there's nothing in writing. So what do you do instead? If your company calls you into a meeting or calls you on the phone and they tell you that they let you go, immediately send them an email, a text message, something in writing where you say, confirming today that at 2 o'clock you let me go. Very important. You do that, that's all you need. That one line, that 5 words can make all the difference. So don't accept and move on with a verbal termination. Put something in writing. Protect yourself so you can get severance and you can get EI.
Okay, one more on our list here, Lior, things you do not want to do as an employee, make assumptions about your employment rights.
You know, we could have started with that. And the reason why you and I started doing the show all these years ago is there's so many assumptions, misconceptions about employment law rights. Don't assume anything. You know, people assume, oh, I'm let go, I'm owed 2 weeks. Or the company can do what it wants because it's the company and I'm just an employee. We have significant rights here in this province, frankly, across the country, and it's not always obvious what those rights are. So don't assume that you know, don't assume that what the company is doing is wrong or right. Make the call. Call me. You don't like me, call another employment lawyer. But when it comes, just like with your health, you're not going to assume things. You have an issue, you're going to speak to a doctor. Well, if there's an employment issue, speak to me, speak to another employment lawyer. Don't make any assumptions about your legal rights. That's a surefire way to give those rights away.
Okay, as we mentioned off the top, you can always join Lior and I pretty much across the country on radio every week. You have been able to do so for about 12 years, right? But here locally in the GTA, it's News Talk 1010 Sundays at 1 p.m. We got another phone call from our radio show. Lior, let's get into it right now.
I worked for a gym for 11 years. I was diagnosed with breast cancer, so I was off for 10 months. I'm happy to say I'm doing fantastic now.
Excellent.
I went into work to say I'm ready to go back to work, and he said, I'm sorry, it's been slow, you're laid off. He's been a really nice gentleman over the years. He's been good to everybody, but people were pretty shocked that I was out of work for 10 months and I wasn't offered a dime.
Wow.
Wow, I mean, this is wrong. You don't need to be a lawyer. You don't need to be an expert in employment law to know that this is wrong. Doesn't matter if a boss was nice, it's illegal. So let's start with the idea, of course, that when you come back from a disability leave, a medical leave, company has to make all efforts to bring you back if it's possible. If to try to put you in the same job, if that job doesn't exist, to try to find another job for you, it's a process they have to go to. They can't just say, we don't want to. We can't say, it's been too long. No, you have a right to be considered and for your employer to make all efforts to take you back. Beyond that, if ultimately there isn't a job and you're let go, you're laid off, well, you're owed severance, of course. And if you're still struggling with your health, it could be even more severance than before, than usual. There's no legal way for the company not to bring her back, let her go, not pay her anything. It's illegal on many, many levels. If any of this sounds familiar to you, it's happened to you before, your company won't let you come back to work, won't accommodate you. If you're let go, laid off, you haven't been paid your severance, do the right thing and do it now. give me a call.
All right, good stuff. We'll take a short break. We got one more phone call to get through on the other side, so stick around for that as we continue with lots more Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back. Thanks for hanging in. Ask a Lawyer here on CP24. Lior Samfiru. Want to reach out anytime. You're always invited to and have that chat on your own time. Phone number, sure, 1-855-821-5900. You want to send along an email, communicate that way. You can do so, ask@EmploymentLawyer.ca. Okay, Lior, as mentioned, a lot of phone calls from the radio show. And one more time, I'll remind you, News Talk 1010 Sundays, 1 p.m. Call the show live, talk to us over the hour, and maybe your phone call will appear on this program. Phone call number 3, Lior, is coming at you right now.
I was just let go from my company, and I've been there 12 years, and I got a severance package. I was just wondering, do they do it like 2 weeks for 12 years payout, or is it a week for every year?
Great.
I'm in my 50s. I was just general labor in a warehouse. They offered me 6 weeks.
See, assumptions.
Exactly.
Right? There's assumptions. We talk about don't make assumptions when it comes to your workplace rights. So no, it's not a week per year, or 2 weeks per year, or any other formula. The main factors are your age, your position, and the length of your employment. And applying those factors, for most people, that means months and months of severance. So this is a terrible severance offer that she got. It's ridiculous, it's insulting, and it's illegal, more importantly. Well, how could she find out about it? How can you find out about your own severance package if you lost your job or are worried about losing your job? Well, here's how you do it. We're going to use this now to tell her how much she's owed. We're going to go to PocketEmploymentLawyer.ca. Use the severance calculator. First thing you see there, and let's use that right now and see what we get. So a laborer worked there for 12 years. Company says 6 weeks is all you got. We're being very nice to you. Well, no, you're not. Why? As you see on the screen, she's owed up to 16 months, not weeks, 16 months of severance. That's how it works. That's how bad an offer this offer is. And that's how easy it is for you at home to find out quickly, free, and anonymously how much you're owed. Just go to PocketEmploymentLawyer.ca.
Got some time. I want to grab an email here, Lior, as we continue on. Says, I just lost my job after 14 years with the company. I did get my 2 weeks pay, but am I not supposed to get vacation pay as well? I also have 2 months of banked vacation time.
Assumption. Right? This is the theme. A theme for the show today is assumptions. You cannot make assumptions as to your legal rights. So this person assumes she's owed 2 weeks notice or 2 weeks pay after 14 years. She's asking about vacation pay. Let's address that first. So first of all, yes, you're owed your accrued vacation pay up to the date of termination and even vacation pay going forward for your severance package. But there's another issue here, a bigger issue, and that is the fact that after 14 years, she's owed a lot more than 2 weeks pay. Now, I don't know her age and I don't know the type of job that she was doing, but she's probably going to be owed somewhere between 12 and 18 months of severance. Months, not days, not weeks, months. So again, very good example here as to the types of assumptions that people make. Don't do that. You know better now. You lose your job, use the severance calculator or call me, do the right thing.
You can always tune in to Lior and the rest of his team doing their live streams on Facebook and YouTube. We'll get to a question from Nat on the other side of the break, which we're going to get into right now. So stick around. More Ask a Lawyer is coming up. This is CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. Dwindling down to our last few minutes. You can always reach out to Lior after the show, though. Always encouraged to do so. The phone number 1-855-821-5900. Email is ask@employmentlawyer.ca. I did mention the live stream, Facebook and YouTube weekly with Lior and some other lawyers in the firm. You want to tune in, go to stlawyers.ca and you can take part. Lior, the question for this week goes like this. Can I ask my employer for time off work to observe a religious holiday? coworkers have told me that our manager often says no.
Well, listen, religious holidays, something that comes up very often. So let's break this down. An employer has to provide accommodation based on religious grounds. That means giving you flexibility if you need to do something to observe your religion. Maybe that means leaving early to make it to church or to synagogue or mosque, or taking a day off for a particular holiday that you celebrate. So yes, the way to do this, though, is to ask your employer, of course, for that time off. Your employer, though, may ask, depending on the situation, for some additional information. They may even ask from a letter from your religious leader. Maybe it's a minister or a rabbi or priest, whoever it is for you. Number one, to confirm that you in fact observe that religion, that it's not just something you're making up, and also that the accommodation that you need is to do something that's tied to that religion. But if you can establish that, yes, an employer is required to accommodate. There's no option. It's not a nice to have. It's something your employer must do. And if they don't, John, that's a human rights violation. It's illegal and can also result in a constructive dismissal.
Yeah, those human rights ones are the ones you got to watch, right? Especially. And a lot of employers wouldn't think this would be. Oh, you want a day off just for that? No, you're going to work like the rest of them.
Yeah, it's not an option. Even if it means you have more time off than someone else for religious reasons, it is what it is. Your employer has to accommodate you. And as long as it's a legitimate request based on a legitimate religious belief and observance, your employer has to comply with that. If they don't, you have the ability to file a human rights complaint or just have me send them a letter. That works too.
And we are up against the clock, so we are just about done for another show. Thank you so much for your contributions on the phones, the radio show, emails, on the live stream, etc. You can always reach out to Lior now that we are done. And that phone number again, 1-855-821-5900. Ask at EmploymentLawyer.ca. The website, pocketemploymentlawyer.ca. And for more information anytime, always cp24.com/askalawyer. Thank you so much. We'll catch you next time right here on Ask a Lawyer. This is CP24.